The court is now back in session. And before we move on to another topic, I would like to give the floor to Judge Lavange in order to clarify with the co-prosecutors. You may proceed, Judge.
Thank you, Mr. President. In fact, we have a question for the co-prosecutors. Bearing in mind the appearance this morning of Mr. Sorin, bearing in mind the position that he reiterated to us, do the co-prosecutors maintain their request that they have submitted concerning civil party Sorin, or do they wish to withdraw it? Thank you.
Thank you, Judge Laverne. The short answer to your question is yes, we maintain our request. For the reasons that I've stated here, it is not for a civil party to make the decision of whether or not he will testify about this critical information. This is a matter that the court should decide, and the court, we believe, must have the power to compel a civil party to provide information such as this. So the short answer to your question is yes, our request remains.
President, thank you. The Chamber now invite the co-prosecutor to address the Chamber first with respect to the request for adverse inferences to be drawn against accused Sampon and Unchi, and second, regarding the admission of documentary evidence and the allocation of E3 numbers. All parties will be allowed to respond. You may now proceed.
Thank you, Mr. President. I will be fairly brief on both of these issues. The first issue, a request that we have made in writing regarding the issue of adverse inferences being drawn from the accused's selective refusal to respond to questions. I will not repeat the arguments that we've made. This issue was brought up in last court. We simply wish to put this issue on the calendar because before, as we are approaching the close of evidence, one of the things we believe needs to be done is to schedule some time for the co-prosecutors to specifically tender to the accused the general subjects on which we intended to submit questions in order to create a record on the specific issues that the accused are refusing to respond to. This is important, as stated in our motion, in order for there to be a record or a basis on which adverse inferences may be drawn. And so the reason for us putting this on the calendar was simply as is stated at the end of the request that we filed on the 16th of July, document E288/4/1. We would request an opportunity in court in the presence of the accused to put before them the general topics or matters on which they would have been questioned and to have them confirm their refusal to respond to those general subjects. In terms of the time, my best estimate, sometimes these are hard, it is hard to anticipate how this would proceed, but our best estimate is that we would need no more than 1 hour with each accused in order to do this. So that is the issue of relating to adverse inferences. The second issue is more of a housekeeping issue relating to admission of documents. Again, it is our request that before the evidence be closed, that the court issue rulings on the admission of documents that remain to be decided. Obviously, in order for us to do our final submissions, which are already in process, it is important for us to know what evidence is admitted and what evidence is not admitted. There are a number of remaining documents, categories, general categories of documents on which we are awaiting rulings, including the witness statements, where there are a large number of witness statements that were the subject of motions and arguments, and a few additional categories relating to certain annexes and new documents. We have also noted, and I wish to bring this to Your Honor's attention, that from time to time we discover a document that appears to us may have fallen through the cracks in terms of receiving an E3 number. There are a number of, for example, there was a revolutionary flag that was in our presentation to the Chamber that still only has a D number. It appears to us that that was simply a clerical issue. So there are a number of documents, and we will submit an email of those that we are aware. But our general point is simply that in order for the parties to do their final submission, we do need to know which documents are admitted. And we, of course, wish to have E3 numbers as much as possible in order to be able to properly reference the documents in our briefs. Those are the two issues that we wanted to raise, and that is all that we wish to say on them. So I thank you for your honors for the time.
Thank you. And the International Legal Lawyer for Civil Parties, you may proceed.
Très brièvement.
Very briefly, Mr. President, we support both the requests put by the co-prosecutors, the first concerning the selective silence of Mr. Kyosampan, and we support the submission E288/4/1 submitted by the prosecution, and we support the request to submit the contents of the question to the accused during a hearing. As to the second request concerning documents, we too would like, as soon as possible, to have a decision from the Chamber making it quite clear what the E3 documents are and which ones can be clearly referred to in the closing arguments and in the final submissions. In other words, we support both requests that have been put by the prosecutors.
Thank you. And what about the defense teams? Do you wish to make a comment or respond to the two requests by the prosecution? Nunchi Defense, you may proceed first.
Thank you, Mr. President. Very briefly, we do, of course, support the second request made by the prosecution. The defense teams, of course, also need, as soon as possible, insight in which documents are going to receive E-numbers. In this respect, I would like to remind you of a request that we have filed and which we have sent to you a courtesy copy. We have indicated in this request that it seems to us that you are on the verge of coming to a decision of possibly admitting around 1,500 documents. In respect of these documents, in the light of this decision, we have filed our request to summon witnesses in respect of the alleged policy of targeting Khmer Republic officials. We understood that a Khmer translation will be finished on Thursday, so then it will be officially filed. But from the courtesy copy, you can see Mr. President, that we have attached an exhibit with names to which about 110 documents refer to. These are names of witnesses who gave statements to the OCIJ. And we would like to draw attention to this list in order to maybe convince the Chamber to give priority to giving E-numbers in respect of documents. So if it is indeed the decision of the Chamber to have these specific documents given E-numbers, then we would like to have the Chamber give these specific documents that we refer to in our annex priority. But in general, of course, we do support the position of the prosecution. We need as soon as possible to have clear which documents are in fact getting E-numbers. In respect of the question of adverse inferences, we do feel that this question is really a matter of closing arguments. I'm not quite sure what the relevance or the purpose would be to give our clients a list of topics on which questions were supposed to be asked. We can all predict the topics that the prosecution and the civil parties were intending to ask questions on. So I'm not sure what the relevance of this is, but at the end of the day, it is a decision which the trial chamber can only do something in its end decision with. So there's nothing at this stage that the trial chamber can do with any submissions in relation to this specific topic. So we do not see the relevance of, or we don't see the purpose of doing this right now, since it is a typical subject belonging to the closing arguments and the closing briefs. So we would object to this session of an hour in which these documents are presented. The new Nigeria defense team knows what the law, what the case law is, if any, in respect of the possible drawing of adverse inferences. We do not agree with the position of the prosecution. We will address the issue, obviously, where it should be addressed, and that is in our closing briefs and closing arguments. So I really see no point, no necessity, no urgent need to have this done at this stage of the proceedings. We have properly advised our client what the possible consequences, if any, would be if he would remain silent. He chose very deliberately to remain silent after the events, the particular events of last Tuesday. In this respect, I can inform the Chamber that we are presently preparing a formal withdrawal of the notification in which our client had earlier indicated that he would answer questions. Hopefully we will finish this withdrawal of notification today, so that it is quite clear and there can be no argument as to why our client decided last Wednesday to remain silent, to invoke his right to remain silent. But these are all, at the end of the day, matters that the Chamber has to take into consideration when coming to its final decision. So there's no place, we repeat that, we reiterate this particular point, to have that done at this stage of the proceedings.
President, thank you. And the Council for Kyiv Sampon, you may proceed.
Thank you, Mr. President. I will be very brief at this stage because we intend to respond to E288/4/1 in writing to the prosecutors, but I would like officially to restate what we did already say at the previous hearing before this chamber, namely that this presentation of issues upon which the prosecution believes that adverse inferences can be drawn against the accused belong in the closing arguments and not here at this juncture. We have the French translation, or rather we do not have the 14 pages in French translation. We do not interpret the text and the consequences in the same manner as the co-prosecutors, and we believe that we are entitled to receive a precise written response with the necessary case law references as well. But let me say that on the issue of principle, we oppose the co-prosecutor's request. That is the first point. On the second matter, the allocation of E3 numbers and the possibility of having a precise list of E3s set by the Chamber, we've already brought this up, in fact, at the last TMM, and I believe that we all agree in this chamber that this is a very important point, because we need to know which documents have been judged admissible, and we need to know on what particular documents you will, of course, base your conclusions. This brings me to a third point that was also brought up at a prior stage, but which is in fact connected with the E3s, as I see it, because I want to refer you to translation problems and to necessary timelines for revising the transcripts of the hearings. We stressed this when we saw occasionally that there were problems of translation or interpretation which led sometimes to mistakes being made in testimony, and it's very important for Kyosampan's team, and perhaps we are not alone in this, perhaps on the civil party side it's the same thing, but we are going to be working on the transcripts in French, and I think we need to have a discussion in this chamber about these documents, and we asked for a fortnight's time to look at these documents, and it's very important that we are given that our resources are limited. We only have one person within our team who is in a position to be able to make a comparison between the three languages and to bring any translation problems to the fore. We will be making submissions on this subject, but I wanted to give you a forewarning of that, because what we are seeking is a final debate on that is the same for all parties, that it's a level playing field between the English, French or Khmer speakers. And we believe, therefore, that this point does need to be stressed in connection with the E3 documents, because you have to know what we are going to be basing, what this court is going to be basing itself on for the purposes of the final submissions. Thank you for hearing me out, Mr. President.
To President, thank you. The Chamber wishes to advise the party that the Chamber will deliberate on this issue, and the ruling will come at the end of today's hearing. Now, turning to the Nguyen Chia defense team's request to summon witnesses in respect of alleged policy of targeting Khmer Republic officials, the Chamber notes that the courtesy copy was provided in English only. It therefore invites the defense to present its argument briefly before the Chamber, following which the other parties will be allowed to respond. The defense for Mr. Nguyen Chia, you may proceed.
Yes, Mr. President. I shall be brief. Most arguments are, of course, within our written filing, which, as I just said, will be fully translated, hopefully, on Thursday. We've also just briefly made reference to the approximately 1,500 written statements which you have indicated will receive E3 classifications soon. And it is in respect of a limited amount of these written statements that we have deemed it necessary not to wait for your decision, but to already file this particular request. The main argument in this request is that there is almost no reliable direct evidence of a policy to execute Khmer Republic soldiers and officials. We have argued, of course, this very same point in our reply to the presentation of the key documents 2 weeks ago. Nevertheless, we have also seen the possibility of an argument presented by the prosecution that the existence of such a policy could possibly be deferred from its occurrence in other parts, in parts of Democratic Kampuchea between 75 and 79. And if we have identified approximately 110 statements in which people possibly speak about targeting of Law and Order officials and Khmer Republic soldiers. We've argued in this request that up until now, once cross-examined, these witnesses seem to be quite unreliable in all aspects of their testimony. Numerous statements are relayed distant hearsay. They often come from unspecified sources. Most of them, when they speak about events, they only say that former Law and Order officials were taken away from a row, from a queue. The evidence that we have identified in these statements is on its face unreliable and has the same value as we have seen during cross-examination of witnesses that have been called before your chamber. Not knowing what the status of these statements of these 110 people is at the moment, we nevertheless thought it was very important to request all those witnesses to appear before the chamber and to give live testimony so that we can cross-examine them on these very issues. You will see in our arguments we have identified certain witnesses who have already appeared before your chamber, what the cross-examination has turned out, what results of the cross-examinations were in fact to be seen. As a matter of fact, the very reason, as we have indicated this morning, that the prosecution is asking for again more witnesses in respect of dual portray is a confirmation of exactly that point that we are making. I do not wish now to go into detail why we object to the admittance of these documents, of these witness statements. You know our position in this. But once you do decide to admit these statements of these 105 or 110 witnesses, then obviously it is of crucial importance that the defense has the possibility to examine these witnesses, to cross-examine them the way that we have done with witnesses who have been called upon earlier before your chamber in respect of, for instance, dual portray or a general existence of such policy. We have, like I said again, identified a list of potential witnesses who could say something about an alleged policy to target and execute former Law and Order officials. We have argued in our request that this evidence is highly unreliable, but nevertheless, if they are admitted, then of course almost automatically our right arises to be able to cross-examine these very witnesses. One last point to the fact that we are now coming with this request. Technically, we, of course, should have waited for your decision to have these 110 witness statements admitted to evidence. At this point, we are still not certain that you will decide to do so. So in this respect, we could even say that our request is early. But assuming that you will, in fact, admit these witness statements as evidence, we thought it was the appropriate time to file that request. But in any case, it is a generally new request which we couldn't have made earlier, since these witness statements were never admitted at this point as evidence. So this is in very broad terms our request, and I would be happy to reply to any observations at this stage, maybe, from the prosecution.
The President, thank you. Mr. Prosecutor, you may proceed.
Thank you, Mr. President. I first would respond to the last words of counsel that technically they should have waited for this filing and that they are early. On the eve of these proceedings being closed at 4 o'clock yesterday afternoon, we received in English only a request from the defense that this chamber call an additional 110 witnesses. Not a request for 1 or 2 witnesses, a request that the chamber call 110 additional witnesses. This request is certainly not early. It is extremely late. This is an issue that the defense has been aware of for a long time. If they wished the chamber to summons some or all, but if they wish to call some of these witnesses, this information has been available to them for a long time. Now, there are a lot of issues that are raised by this motion, arguments made regarding the court's reliance on witness statements that we believe are incorrect and contrary to the rulings, incorrect assertions of the state of evidence in terms of what it proves regarding policy. In view of the fact that this request was just received at 4 o'clock yesterday, we would like the opportunity to file a written response to it because it raises important issues. Nonetheless, I will make a few brief comments today based on the little time that we have had to review it. First, I do wish to note that the defense misstate the issue here. They focus exclusively on a policy to execute, a policy to kill or execute soldiers and officials from the Khmer Republic regime. And I would remind the defense and the chamber that the policy and issue here is broader than that. It is a policy to target people in this group. The crimes with which the accused are charged are not just murder. They are charged here with persecution on political grounds, meaning discriminatory acts against this group of individuals. So when the defense dismisses evidence that merely shows that these people were segregated, that they were arrested, that they were sent to re-education centers, they are misleading the public and the chamber. That is evidence that proves the policy with which they are charged and the crimes with which they are charged. And I refer specifically here to closing order paragraphs 1416 through 1417 which are the paragraphs specifically relating to the crime of persecution on political grounds. That is one general observation I would make on the motion. Second, there is a significant amount of posturing and misstatement in the motion. In some ways, this is an attempt by the defense to have early closing arguments on this issue. I will not today engage the defense fully on this, but I do wish to say, for the record, that assertions such as are made in this brief, that there is almost no evidence of this policy, we vigorously disagree with. The characterization of some of the witnesses by the defense, the characterization of their testimony, we disagree with. Let me give you just one example. The defense assert that the testimony of Mies Bun in no way supports the existence of a policy targeting Khmer Republic soldiers. I would remind the Chamber and the defense that Mies Bun, who was the deputy commander of the West Zone Army, testified that there was a special unit in the military that was tasked to review the biographies of cadres and to purge persons who were identified as having connections with the prior regime. That was the testimony of Mies Bun. The defense has given you a list in which it acknowledges that there are 21 witnesses or civil parties who have provided testimony to the court on this issue. So the court has heard a substantial amount of testimony. And I would note here, again, without getting into too many details, that the defense list leaves out a number of significant witnesses who have testified on this issue. Al Rockoff, Sidney Schanberg, Philip Short, and most significantly, Deutsch, the chairman of S21, who testified that the first group of victims who were targeted in the early days of S21 was this very group, persons associated with the Lon Nol regime. So we very much take issue with the characterizations and arguments in this brief. As I indicated, we would propose to do a written filing on this issue in order that there be a complete record. It is a lengthy filing that makes a number of misstatements. But for the benefit of the court, these are the general observations I have, having received the motion yesterday at 4 p.m. I thank you for the time.
The President, thank you. And the international lead co-lawyer for the civil party, you may proceed.
Oui, merci, monsieur.
Yes, thank you, Mr. President. Very briefly again, we endorse the position of the co-prosecutors in the face of this application made at the very end of this trial to hear 110 additional witnesses. This is purely dilatory to try to justify the application. My learned friend writes that the need to hear these witnesses is the fact that we've heard some of them and that those heard are not reliable. This is his personal view, and he can elaborate on it in the closing briefs. And it's up to the chamber to assess the reliability of the testimonies of witnesses already heard. In the face of this request, I wish to point out that my learned friend has not quite understood the use to have a trial with pre-trial investigations and to hear witnesses who have been called, and that it is not necessary to summon more witnesses. The investigative report is something that is reliable, and it is absolutely not necessary to hear all the persons who have already been heard by the co-investigating judges with derogatory letters. So I would request the Chamber to reject all these applications.
The President. Mr. Victor Kope, you may proceed.
The last observation is very interesting, then, because it begs the question what we have been doing in the last 2 years at this trial. Most, if not all, witnesses who have appeared here had in fact given testimony to the office of the co-investigating judges. So if we could just simply rely on their statements, then this whole trial of 2 years wouldn't have been necessary. So I take it that you do not take this remark of the civil parties very seriously. The other thing is, yes, on the face of it, it might seem very late, our request to have 110 witnesses appear. But on the other hand, as I explained earlier, all these documents that we have referred to in our attachment are not yet admitted. There's no formal decision of the Chamber to admit these written statements. Of course, I will not advise the Chamber that there would be a very easy way out in respect of this request, simply by not admitting all those documents that we refer to in our annex. But if you have done so already, then again, like I said, the first possible moment to file a request to have these witnesses cross-examined comes exactly after the admittance of these very documents. So I will repeat my earlier observation that we are in fact, technically speaking, premature, because all those documents, all those witness statements have not in fact at this point in time be admitted as evidence to case 002/01.
The President. Thank you. For this, the Chamber informs the party that this request will be addressed as part of the witness statements decision, which the Chamber will address later in this hearing. And since this request has been responded orally, the Chamber does not require the party to file any written submission in this respect. The Chamber now turns to the Khieu Samphan defense team's request for information with respect to the condition of Nu Muk's appearance before this court. And the Chamber therefore invites the defense the Chamber therefore invites the defense to represent its argument briefly to the Chamber, and following which the other parties will be allowed to respond. I hand over the floor to the defense team for Mr. Khieu Samphan first. I hand over to the defense team for Mr. Nuon Chea first.
I apologize. I'm not quite sure what to answer to what. Sorry, Mr. President, I didn't get it.
Oh, well, yesterday, the Chamber is seized of the request by the defense team for Khieu Samphan, defense team requesting for information with respect to the appearance of Mr. Nu Muk, and this request was filed with the Chamber yesterday. And now the Chamber invites the parties to make observation in response to this request by the defense team for Mr. Kyew Sampon. And since this request was made by one party, then this request shall be observed by other parties. So if you have any observation, you may proceed, but otherwise we may cede the floor to others. Because the chamber would like to make sure that everyone has the floor to make any observation in respect of the submission by other parties. You may proceed.
I understand. Thank you, Mr. President. We have no observations.
The President, thank you. Now I hand over the floor to the prosecution. You may proceed.
Thank you, Mr. President. I will be very, very brief on this motion, which we also received yesterday afternoon. The motion asks the Chamber to conduct further investigation relating to the circumstances under which Nu Mu was provided with a photograph of Ben Kiernan and provided with notes of his prior interview by Ben Kiernan. Simply put, our submission is that no such inquiries or investigations are necessary here. The trial chamber itself has already explained during his testimony the reason that the photograph of Ben Kiernan was used by Wisu, which was to ensure that they had correctly identified the witness that they were searching for. And in regards to the notes of the interview, it does not strike me that there is any harm that has been caused by a witness being allowed to see notes of an interview he provided. It seems to me that that is a fair opportunity for a witness who is going to testify to have an opportunity to review the material on which he will be examined. This witness made corrections, or when he believed that the notes did not accurately reflect his memory, advised the court of that. So I simply fail to see why there is any reason for the court to conduct further inquiries on this issue, and we would request that the motion be denied.
The President, thank you. Now, lead co-lawyer for the civil party, you may proceed. Counsel Pech Ong. Thank you, Mr. President, and good morning, Your Honors. We at the civil party, we concur with the prosecutor that there is no specified reason to conduct further investigation in relation to this particular witness, Mr. Nu Muk. Like the prosecutor, we suggest that this motion by the defense team for Mr. Kyew Sampon be rejected. Thank you. The President, thank you. Madame Antagise, you may proceed.
Oui, Monsieur le Président.
Yes, very briefly, Mr. President. You would recall that during the appearance of that witness, Nu Muk, I, the person who examined him, questioned him on two main points. One, under what conditions the photograph of Ben Kiernan was given to the witness, and secondly, when he became aware of the notes of Ben Kiernan during the interview he had with him. Regarding the first point, you would observe that it is not simply a question of having the chamber's answer that the photograph was shown him for identification purposes. As you know, my request is a lot more specific. That is, under what conditions the photograph was shown him and at what point in time he got it. This point is very important because we recall that Ben Kiernan's name was written on that photograph. Again, in our submissions, on which I will not dwell, the conditions under which he received the photograph are very important because we are asking for further information because we want to know when, at what point in time, the testimony of that witness was contaminated by information he received before appearing before the chamber to give evidence. Secondly, regarding the notes of Ben Kiernan, I believe the chamber in its prior decision was very clear. There is no problem in us receiving statements that are signed and certified by the witness, but when we are dealing with information that is external to the witness, that is notes that the witness received and information that wasn't obtained at the time of the interview, then it is important to know. And we cannot know unless clear questions are put to the witness. If such questions are not put to the witness, it is not possible for the parties to know when the information was requested, when the witness was oriented or guided or not. So these points are very important. We cannot use notes taken by a person during an interview and attach them to a statement that was signed by a witness, and that is in the witness's language. And that is why we wish to know when those notes by Ben Kiernan were given to the witness. And we wish to know whether they were shown to witness before his appearance. That is a statement that was signed and read by the witness. This is very important. We have already emphasized this point. There have been lengthy debates on this during witness Numok's appearance. And this was eluded with the statements that contradicted one another. We have notes here that do not tally with the statement that was read and signed by the witness. If that was received before, that would definitely have an impact on how you would assess the witness's testimony and the probative value you would give to the witness's testimony, given the fact that there's a likelihood that the testimony was contaminated. This is the information I wish to provide at this point. We will elaborate on this in our submissions, and I reject entirely the arguments of the civil parties and the co-prosecutors that the witness was given that purely for identification purposes.
The President, thank you. Now it is an appropriate point to break for lunch. The chamber will adjourn now and resume at 3 this afternoon. The chamber wishes to advise the parties that this afternoon the chamber may be in a position to issue all the decision concerning all the application and requests filed by the parties, and after that the chamber will also announce the future scheduling from this point forward. Security guards are instructed to bring Mr. Kyew Sampon down to the holding cell and have him return to this courtroom this afternoon before 3 o'clock. The court is now adjourned.
សូមអញ្ជើញក្រោយចូល